It's time for some trailblazing justice. Steve Wax, Senior Counsel at OJRC, is back for another episode in our special series, Waxing Confidential. What if your right to challenge an unjust imprisonment was the last line of defense against authoritarian rule? In this episode, we trace the ancient roots and modern battles over habeas corpus, from medieval England to Guantanamo Bay to present-day America, uncovering how this vital legal safeguard is under renewed threat, as political leaders hint at suspending it under dubious claims of, quote, invasion or insurrection. This episode raises an urgent warning. Democracy may hinge on whether we protect this fundamental right. This is Trailblazing Justice, the weekly podcast where we discuss civil and criminal rights in Oregon and beyond. Trailblazing Justice is a production of the Oregon Justice Resource Center. Episode 64, recorded Tuesday, May 13th, 2025. Waxing Confidential, Habeas Corpus is for lovers. Here's Bobbin.
Welcome back to another episode of Trailblazing Justice. I'm Bobbin Singh, the Executive Director of the Oregon Justice Resource Center. And today we are doing our third part in our series, Waxing Confidential. And we're back with Steve. The last two conversations or recordings that we did, Steve discussed the attack on the rule of law. And last week, we talked about some parallels that he saw between pre-Nazi Germany and then the United States as currently, and gave us just a brief background on due process and habeas corpus. Today, we're going to dig deeper into habeas corpus because it is such a significant tool in American law. And based on what happened this past week with the administration talking about the suspension of habeas, we wanted to spend some time discussing this a bit more. And, one of the leading practitioners of habeas is Steve himself, who helped lead the federal defender office here in Oregon and helped develop it into one of the most respectable federal defender offices as it relates to habeas practice in the country. So, Steve, welcome back. And should we just talk? You want to give another introduction or overview of the history of habeas, what it is, and why, how it came to be in U.S. law?
Sure, Bob, and thank you for continuing to do these podcasts and for the invitation to participate. Habeas corpus has its origins in the Magna Carta. The Great Writ was not incorporated directly in Magna Carta, but in 1215, when the barons reigned in King John of England and created a set of rights, including a right that's quite analogous to our due process right, the seeds of the writ of habeas corpus were planted. In 1305, there was a statute passed in England that was probably the first incarnation of habeas corpus. In a nutshell, habeas corpus, translation, bring the body forward, meaning that if the executive, originally the king, now president, Bureau of Prisons, state governor, State Department of Corrections, is holding a person in custody, that person has, in some circumstances, the right to petition the courts in our country and in England for the determination of the legality of the detention. This is not, part of a criminal process. Person's arrested, indicted, charged. You go to trial. You can appeal. This is something that is outside of that. The history, again, going back to England, in the 1600s, the writ of habeas corpus, called a petition of right, was well established, and it was used against King Charles, who had put some people into the Tower of London for not wanting to assist him paying taxes in a war that he wanted to prosecute against Spain. So he suspended Parliament, suspended the writ, led to the Civil War in England. And in 1679, the English passed a writ of habeas corpus statute that is pretty much the forerunner of all other statutory developments of the writ. When the colonies were formed, Most of them created their own constitutions, and those constitutions in most of the colonies included the right to a writ of habeas corpus, called that. You get to the founding of the United States in the Constitutional Convention in Philadelphia in the late 1780s, and passage in 1789 of the first Judiciary Act enacted by the United States Congress. One of the first statutes that they passed was the Judiciary Act of 1789. And that statute included a right to petition for a writ of habeas corpus. Interestingly, and I think highly significantly, the Constitution itself, neither the original Constitution nor the Bill of Rights, when it was added just a couple of years later, included the writ of habeas corpus as something that was affirmatively stated. Instead, it was perceived to be such a fundamental part of our nation, the creation of a government for this nation, that all that was needed, according to the founders, was the statement that the privilege shall not be revoked, could not be suspended unless there was an invasion or an insurrection. Now, the writ as it existed under the Judiciary Act was a prohibition on, or I shouldn't put it that way, was a right to petition the judiciary for unlawful incarceration by the federal government. It wasn't until the Civil War, when the 14th, 13th, 14th, and 15th Amendments were passed, that both due process in the Constitution and the 14th Amendment was made applicable to the states, not just the federal government, because the due process clause of the Fifth Amendment required process by the federal government, and most states had their own due process clauses. But the 14th Amendment enabled people to say to the federal government that the states were violating their due process rights, and to appeal to the federal courts through the habeas enactment post-Civil War that the state courts had violated their federal constitutional rights by the fact of incarceration. The most people, if you think of habeas corpus, think of, some, writ out there, telling the government that it cannot keep you in prison. Most of the cases that have come up in the United States, particularly, specifically since the Civil War, are challenges by prisoners who've been convicted in the state courts of a crime, have unsuccessfully suggested and said to the state courts that their federal constitutional rights were violated. And then they go to the federal court and they file a writ of habeas corpus and say, hey, federal judges, the state is holding me in custody in violation of my federal constitutional rights. Now, that's not an appeal. I mean, you go through your appellate process. You can ask the U.S. Supreme Court to review the decision of a state Supreme Court on appeal. This is a separate petition saying my federal constitutional rights are being violated, therefore my imprisonment is unlawful. And, during the course of my time in the Federal Defender Office, we represented people in about 3,000 challenges in the federal court to state court convictions. Reality is that the overwhelming majority of those petitions lose for a variety of reasons, some of which are procedural, most of which are substantive, that the federal courts are not going to find a violation. When I say procedural, I mean the federal courts are saying that the prisoner did not comply with state procedural rules, therefore the federal courthouse door isn't even going to be open to look at the underlying claim. In the Federal Defender Office here in Oregon, however, we've had several sets of habeas challenges directly to actions of the federal government. The first was a series of habeas cases challenging the unlawful detention of people who had entered the country illegally, had not committed any crime. Normally, they would have been deported back to their home countries, but we have statutes that prohibit removing a person or sending a person back to a country that's on a list of countries where there is torture and other very bad prison systems. But what happened in the late 1990s was that throughout the country, thousands of people, and here in Oregon, hundreds of people, were held in county jails for sometimes 2, 3, and 4 years because they couldn't be sent back to their home countries. No crime. And in county jails, I mean, you rarely get to go outside and breathe fresh air or see the sun. There are no programs. You hardly ever get to work or do anything. And we brought several hundred habeas actions in the federal district court here saying that the executive, Clinton, then Bush, was acting in violation of the Constitution by keeping these people in custody. They were what was called paroled into the country under supervision. And some eventually went to other countries to settle. Some did go back to their home countries. Most eventually were able to legalize their status in this country. Second place in which the Federal Defender Office got involved in direct habeas challenges to executive incarceration was in the case of the prisoners, the men who were held in Guantanamo Bay, people who had been picked up sometimes on the battlefield in Afghanistan, sometimes from their apartments in Pakistan, sometimes picked up in Bulgaria or other countries, but held in CIA black sites, prisons where the CIA had an agreement with the home country to have a prison there, and they were brought to Guantanamo. And we challenged the fact that they were being held in Guantanamo with no process. That President Bush had said, I, as the president, have the right to incarcerate you, the right to make my own determination of whether or not you are an enemy combatant. And they said, the Bush administration, that the federal courts had no jurisdiction over those people. Supreme Court in 2004 said, well, yeah, you're wrong. There is jurisdiction. Guantanamo is a U.S. military installation. There's jurisdiction there. Therefore, these men are entitled to some process. What happened after that was that the Bush administration and Congress passed what was called the Detainee Treatment Act, which included repeal of a portion of that first Judiciary Act passed in 1789 that created the writ of habeas corpus. And we challenged that along with other lawyers. Our cases were not first in line, but we wrote amicus briefs that went to the U.S. Supreme Court that said in 2006, you can't repeal that statute. What you created is not a sufficient replacement for it. So they rewrote the statute again, still repealing this habeas statute from 1789 and passed the Military Commissions Act. 2008, in a case of an Algerian named Lahmar Boudmerienne, the Supreme Court reached the constitutional issue and said, writ of habeas corpus is so fundamental. Justice Kennedy traced the history back to England, back to the 1600s, and said that the people held in that prison were entitled to habeas corpus hearings. I wrote an article that the Oregonian published back then. Their title on it was Habeas Review More Important Than Ever. And my thesis back then was how fundamental the writ of habeas corpus is to a democratic system as opposed to an autocratic system. An autocratic system being defined as one in which the executive, president, governor, king, can make his own determinations about the legality of detention. And my view then and my view today is that eliminating the right of people to go to an independent judiciary to challenge their imprisonment by the executive is a very, very significant and long step down a road to an autocratic and authoritarian system. And the English learned that many, many centuries ago. The founding fathers of this nation, both in the colonies in the 1600s and 1700s and in Philadelphia in the 1780s, understood that with crystal clarity. And that is, that's the history. And, this may be a place, Bobbin, to talk about the current administration's.
Well, I want to get there, but you've mentioned a lot.
Right.
And so I just want to kind of reflect back
Sure.
a couple of things, but then also ask you some clarifying questions or thoughts. So, this right so fundamental that the Constitution itself doesn't even explicitly authorize it, except that it cannot be suspended. That's how fundamental that this right is. And, you talked about how there are essentially two different reviews, and under one of them, some subcategories, but one review for habeas is the state incarceration getting federal review, and the other one is federal action that's being reviewed or by the executive. But I just want to go back to this idea of federal versus state. Why is it so important, and you alluded to this about an independent judiciary, that there be the ability for someone in state prisons, because this is a lot of the work that we do as an organization, that we work with people in state custody and state prisons. We've talked about how the criminal system primarily operates at the state level through counties, into jails, and then eventually into prisons if you're convicted for a felony of been serving more than a year here in Oregon. But why is it so important that state prisoners have the ability to go into federal court? I mean, we have a state habeas, here, but what is the significance of that?
The significance of a right of a state prisoner to petition the federal court is grounded in several things. First and foremost, the federal Constitution is something that the states must follow. But state court judges have in the past, and undoubtedly will in the future, take a different view of what the federal constitutional provisions mean than do the federal courts. That can happen for a variety of reasons. One is, in most states, judges are either elected or they are appointed through a highly political process. The election of judges with fixed terms has a tendency to make them less independent than federal judges who are appointed for life. Now, reality is that sometimes people on both sides of the political spectrum really regret the fact that federal judges, particularly Supreme Court justices, are appointed for life. And there have been suggestions that, maybe age 75 is long enough, or maybe 18 years is long enough. Those suggestions are different in kind than what exists in most states, where an election requires judges to run perhaps every 6 years for re-election. What happened in Wisconsin this spring is a great and recent example of the dangers of an elective, politicized process for selecting judges. State of Wisconsin had a race for a Supreme Court justice seat. Elon Musk threw $25 million of his own money into that election. One could say, in an effort to buy the seat for a person who was running on a platform which has nothing to do with the state of Wisconsin, a platform that was aligned with Musk's leader, the President of the United States. Now, he lost. People of Wisconsin rejected Musk's effort to buy the election, for sure. But that is not always the case. California, our neighbor to the south, a number of years ago, had a Supreme Court that issued a number of decisions that were favorable to the rights of defendants in criminal cases and people who were in prison. A lot of money was thrown into an effort to get rid of the state Chief Justice, Rose Bird, and they were successful. So the feds, the federal government, the federal courts, whose primary responsibility it is to uphold the federal Constitution, are a backstop, a fail-safe for situations in which the state courts are misinterpreting the federal Constitution or have been shifted in a particular direction by moneyed interests and or efforts to limit what they can do in a way that would not allow them to or leave them any interest in vindicating federal rights.
I mean, it's so interesting because when we talk about checks and balances, we always generally think, I think commonly among the public, you think about horizontal checks and balances between the different branches of government, the legislature, the judiciary, and the executive as being co-equal branches of government and having the ability to check the other in some way. I mean, that's sort of the beauty of the construction of our government. But I think this idea of like this vertical check, which is so important in our criminal system, you have all these rights that are in theory given to you to protect an illegal conviction or incarceration up front. You go through the state system and you have all your appeals, but to the point you're saying, there could be, and the thing that you also mentioned last time, you could have an overzealous prosecutor, a corrupt judge, a defense attorney that's sleeping at the table, the common meme or the, stereotype of an ineffective assistance of counsel. You have all these things that could work in an ugly choreography that results in unjust incarceration. And then you have this, what is a very, again, elegant sort of vertical check that you have this ability to go outside this system and have something else look at it and help circumvent perhaps that level of corruption or dysfunction or impropriety that may have existed. So it really is so fascinating to see that all play. And I think that the next question I have is, you said you had a number of habeas cases when you were the federal defender, um, and and you said a lot of them did not win. And I just wonder if you could speak to like how extraordinary it is to get habeas relief, and then also maybe how the Supreme Court has what role that's played in narrowing the ability for people to get habeas relief.
Sure. The Supreme Court has played a huge role, and so has Congress. So the Supreme Court, starting in the very 1950s, and then in a case in maybe 1963 called Fay v. Noya, expanded the right of state prisoners to seek relief through habeas in the federal courts. And throughout the 1960s and on into the 1970s, people were able to challenge their convictions in the federal court and present new evidence. So, for example, I need to take one step back here, Bob, because we need to distinguish between habeas relief as a way to vindicate innocence, as opposed to habeas relief as a way to vindicate your right to be free from incarceration by an unlawful process. So one of the things that I always say when I'm talking about my role as a criminal defense attorney is that I was fighting for two things in all of my cases. One, fighting for my client and doing whatever I could to convince a jury, if we had a trial, which was rare, that the client was not guilty, or to minimize the degree of punishment. But my second goal, my second obligation as a criminal defense attorney was to ensure that my client was treated fairly and legally by the system. I always say, if my client committed a crime and you have evidence that can establish guilt, evidence that was lawfully obtained and lawfully presented, and the client goes to prison, the system has worked.
Mm-hmm.
And I would always tell my clients that, I'm here to vindicate your right to a fair process. Understand, I will do that even if you tell me you did it. I still say that before the state can take away your liberty, they have to follow the law, play by the rules before they can put you in prison. And if they don't, doesn't matter that you committed the crime. Again, the system has performed properly. And that latter aspect has nothing to do with guilt or innocence. It has to do with the fact that if the government wants to put any of us in prison, they need to do it according to the law. And if they don't have the right to put you in prison. So, in habeas, most of the challenges to a conviction are not based on innocence. They're based on the fact that the government violated the law.
Mm-hmm.
The government could violate the law by having favorable evidence that they don't turn over as they're required to. They can violate the law by knowingly using perjured testimony. They can violate the law by providing a lawyer who is ineffective. You mentioned, lawyers sleeping. Lawyers literally have fallen asleep at the table, and so have judges. You can't have a fair process if your judge is, bought and paid for. That happens. Or if your judge falls asleep and really isn't presiding over the trial. Those are the types of things that can lead to having a conviction thrown out and the person then getting a new trial ordered where the state has the opportunity to get the conviction again as long as they play by the rules.
And we talked a little bit about this last week when we talked about due process. And, again, if the process isn't fair, this is one tract in which habeas, like you just elegantly explained, that habeas can provide an opportunity for people to have relief, right?
Yes. Yeah,
An
right.
unfair process somehow. So then you're also saying there's that second category of habeas for habeas relief that exists. Can you explain that? I mean, you talked about it last week, but you talked about the innocent person.
Sure. Before I get to innocence, you asked what's the role of the Supreme Court and Congress in making it difficult? Well, starting in the late 70s and then throughout the 1980s and 90s, the Supreme Court handed down a series of cases that said, if we're going to open the courthouse door to you so that we'll hear your underlying claim of ineffectiveness of your lawyer or bias by the judge or what have you, you need to comply with all of the rules that the state has set up for you to challenge your conviction through the state trial and appellate process. And their decisions made it more and more difficult for people to even get the federal courthouse door open.
Mm-hmm.
It became a game of gotcha. And one of the clearest examples is, everyone knows about the Miranda warnings. You have the right to remain silent. You have the right to have a counsel. If you can't afford a lawyer, we'll appoint one for you. Well, if a person who had a confession taken from him improperly says, oh, you didn't tell me that I had a right to remain silent, but doesn't say, you didn't tell me you had a right to counsel, the Supreme Court says, oops, sorry, you're not going to get relief because we're not going to hear your claim about not having had counsel because you didn't say that in the state court. Yeah, so what? Your right was violated. The confession was obtained unlawfully. But if you don't jump through the right hoop, the Supreme Court said, you're not going to have your claim heard. And then in 1996, in a statute promoted by the Clinton administration called the Anti-Terrorism and Effective Death Penalty Act, Congress passed a law that made it even more and more and more difficult to have your claim heard or for the federal court to actually review what happened. I started to say a couple of minutes ago that it used to be if you had new evidence. Let's say that your lawyer actually was asleep, but you don't present the videotape of the lawyer snoring. There's a camera in your state courtroom and it videotapes your lawyer snoring. You challenge your conviction in the state court and go through the state process and say, my lawyer was asleep, but you don't present the videotape of him actually sleeping. And the state court says, no, I don't have enough evidence here, denied. And then you find the tape of the lawyer asleep. Under the Supreme Court and congressional action, you can't give the federal court that new tape. Now, I think that's absolutely absurd. Mm-hmm. I argued a case, Keeney versus Tamayo-Reyes, in the U.S. Supreme Court in 1992 on that very issue. New evidence. And we lost 5-4. It's just wrong. But they wore the black robe, not me.
Yeah, it's interesting. Stephen Bright, who's like a well-known defense attorney and civil rights advocate based out of Georgia, he talked about in a documentary when he was giving an interview talking about justice, like what is justice? And he talked about these procedural barriers. And I'm maybe messing it up just a little bit, but the point I holds is that he was talking about, you try to, file for an appeal, but you're 3 days late. And, he says, denied, appeal denied, Whereas like that's not justice. Justice would ask, why was it late? Why is it important that, that those 3 days matter on a death penalty case, for example? Like, does it really matter? Or are we just making up these arbitrary rules at some point? But I think to the point you're making, there's all these rules that are in place that don't make any sense, that don't actually ask, does this make sense when we're trying to understand, was this person treated fairly? Was this person convicted correctly? And yeah, and I think I've heard other attorneys say similar things that this is just the type of dance that you have to get to be able to open up the federal courthouse doors now is so extraordinary.
It is, and it has nothing to do with justice or fairness. Yeah, the courts posited a dichotomy between fairness and finality. That is, the state courts and victims have a right to, finality of judgments. Yes, I understand that closure and finality is an important value, but to exalt finality over fairness seems to me to be fundamentally wrong and violate a person's right to due process. A person was literally executed in the case that you mentioned, that Steve Bright talked about, because the appellate papers were filed 3 days late. And the Supreme Court allowed the execution to go forward without anyone ever looking at the underlying claims. That's just wrong. Now, the question about, actual innocence. Because the law is sometimes a bit of an ass, there are two types of actual innocence in federal habeas. The first would be, one would think, you can come into court and you can say, look, my right to due process, my right against cruel and unusual punishment under the Eighth Amendment was violated because I'm innocent in fact. I just didn't commit the crime. Here's the DNA proof. Here's the videotape of me being in, Miami when I'm supposedly in Portland, committing this crime. The Supreme Court, in a case called Herrera v. Collins in 1993, said, well, we don't think that any such claim exists. Now, as you look at the opinions, there were 6 justices who actually sort of did seem to say that you can raise actual innocence to avoid the death penalty. But that was not the holding of the court. And in the next 32 years that have passed since Herrera was decided, neither the Supreme Court nor any appellate court, except with one exception, has held that actual innocence is a substantive claim that can cause a federal court or support a federal court's granting relief and ordering you released from prison. Now, talk about George Orwell and doublespeak in 1984. I don't get it. I mean, I'm innocent, but I can't be released from prison by proving my innocence as a federal claim against due process violation. Life, liberty, due process protects life and liberty. That's what the Supreme Court has said. All right. So a few years after the Supreme Court said that, the case came to them in which a person had not complied with all of the state's procedural rules and was told that, as a result, the federal courthouse doors are closed. You can't present your claim. Supreme Court said, well, we're going to make an exception. If you can give us enough evidence of your innocence, we'll open the federal courthouse door. So from 1996 through the late teens, that exception, the actual innocence exception, was something that allowed people to get the doors open. And I'll give an example from one of the federal defender and Oregon Innocence Project cases about that. But then in the late teens, 20 teens, the Supreme Court went back to this notion of, but you can't give us new evidence. So they made it far more difficult to prove actual innocence, to overcome the procedural default, if you didn't give that evidence of actual innocence to the state courts in your earlier proceedings before you came to federal court. I mean, it's catch-22 after catch-22 after catch-22. Notwithstanding that, every year there are a handful of people around the country who are granted habeas relief based on proving actual innocence to overcome the default, and then they are granted relief based on an underlying claim such as ineffective assistance of counsel, prosecutorial misconduct, judicial bias, racial bias, etc. So one of the Oregon Innocence Project's clients over the last few years was a woman named Lisa Roberts, who was also the last federal habeas case that I was involved in the federal defender office. Assistant Defender Tex Clark handling the case. I got into it when she went on sabbatical, and things got blown open by some new DNA evidence that the federal court, after 4 years, had finally ordered the state to give us the DNA so we can do some more testing. And in Lisa's case, we, with DNA evidence, with a challenge to some very bogus evidence presented or proffered by about cell telephone technology and investigation into the background of the person whose DNA was found on the victim, a male. Lisa, a female, could not have left that DNA. Judge Marsh, federal Judge Marsh, unfortunately passed just a couple of months ago, found sufficient evidence of innocence had been presented, and then granted relief based on the ineffectiveness of her state trial lawyer for not challenging the cell tower technology evidence that the district attorney had brought up. But that's an example of a case in which Judge Marsh found enough evidence of innocence to say, I'm opening the courthouse door. But if this substantive claim of innocence even exists, the standard there is so high, I can't quite say that there's no juror anywhere in the world who would not have convicted you. And unless I can say there isn't even one juror anywhere in the world who would have convicted, I can't say that you've proven your innocence enough to grant relief based on actual innocence alone. I mean, it's absurd. Mm-hmm. That's the law. Fortunately, Lisa was released in 2014 after Judge Marsh's ruling, and has been a very loyal supporter of the Oregon Innocence Project, which has helped her along the way ever since.
I mean, it seems like the whole spirit of habeas, the whole purpose of it is to have this check, to really examine whether or not the state or executive is illegally detaining you or incarcerating you. And we'll jump now very quickly into this other bucket of like the second sort of category of innocent people. But like all these rules and mechanisms and burdens, it's as if the federal court has basically said, okay, like, yeah, we understand the spirit of habeas, but we really don't care or believe in it. And, we're going to just kind of keep winnowing away at it. And, and it may exist, but it's only going to exist in the thinnest, most, weakest form that it can exist. And that seems to be the feeling about it, at least in the instance of like in the context of these criminal cases that you're talking about.
Well said, Bobbin. Well said.
So, all right. Well, now that people, I guess, have some sense of habeas in that context, let's talk about the other one that's, I think, that's more relevant right now and front and center in the news. And we'll get to what the administration and Stephen Miller said. But can you set up at least this other sort of innocence kind of protection that habeas is supposed to protect?
You're referring to the executive imprisonment and potential suspension of the writ, wartime, insurrection, Guantanamo, etc.
Yeah.
Sure.
Yeah.
So in England, the writ was used 16, 17, 1800s to get people released when the king, or sometimes it was the navy, as a branch of the executive, the king, threw people in prison without any process, or with an entirely defective process. No right to see the charges, no right to confront your accusers. I mean, all of the other rights that we talked about last time that go into a fair process. What does due process protect? So in the US, with the narrow grounds for suspension, the writ of habeas corpus has in fact been suspended 4 times in our history. During the Civil War, President Lincoln suspended the writ. His suspension of the writ raised the question of whether the executive has the authority to suspend the writ, or whether that can only be done by Congress, because the suspension clause exists in Article 1, Clause 9, or Section 9. Those are the powers of Congress. There was no question raised in Lincoln's suspension of the writ about whether or not the conditions of invasion or insurrection were met. Civil War had begun. South had declared war. The Civil War was underway. There was an insurrection. When Lincoln suspended the writ, there was a huge outcry as to whether or not he could do that. Now, he did it while Congress was in recess. So if you have an emergency, if you have a group of states who have declared an insurrection, we no longer want to be a part of you, if you're engaged in a civil war, legitimate question whether or not the president would need to wait to suspend the writ so that he could throw people into prison who were engaged in this insurrection without going through any process. The issue was settled because when Congress came back into session, they ratified Lincoln's suspension of the writ, and then a little bit later on in the war, granted him the power to suspend the writ. Okay. We then go to World War II. Japanese bombed Pearl Harbor, December 7, 1941. Hawaii, where Pearl Harbor was located, was a territory then. It was not a state. Hawaii was governed by what was called an Organic Act. The Organic Act of Hawaii had a suspension clause in it. The suspension clause of the Hawaii Organic Act did not specify that it was only a legislature or the U.S. Congress that could suspend the writ in the event of invasion or insurrection. Well, again, 1942, when this occurred, there was no question. There was an invasion. Japanese had attacked the territory of the United States, to wit, Hawaii. And the suspension was upheld based on the Hawaii Organic Act. Now, in World War II, there was an executive order issued 99,000 something, 9,600. I don't remember the
9666.
9666.
9066, yeah.
9066. For the incarceration of Japanese who were lawfully in the U.S., were citizens of the U.S., were residing, if I'm remembering correctly, in the western section of the United States. And the incarceration was based on this executive order, which was clearly imprisonment, executive imprisonment without process. Procedures were set up for the people who were imprisoned to, get out of prison. And, any number of people who were put into the camps, the prisons, were released. There were Japanese, men who were released to join the United States Armed Forces and served with great distinction in the European theater, not in the Pacific theater. Justice Douglas, who authored one of the opinions of the Supreme Court upholding the incarceration, later said it was the worst decision of his life, something that he regretted, and an embarrassment to him throughout the rest of his career. 1986, I believe it was, Ronald Reagan, President Reagan, on behalf of the United States government, apologized for the incarceration of Japanese Americans during World War II. And if I recall correctly, the Congress appropriated $25,000 per person for those people who had been victimized by the incarceration. That's, as I understand it, the extent of the suspension of the writ of habeas corpus in our history. The other effort to suspend it by repeal of a portion of the Judiciary Act with the Guantanamo prisoners I've already talked about. And the challenges, to the incarceration, both in the Civil War and, in the, during World War II, met with, different degrees of approval or disapproval as time went on. There was a case, Ex parte Milligan. I'm trying to recall Ex parte Milligan. It was after the war was over. Milligan was vindicated. The Supreme Court held that his incarceration was unlawful because he was tried in a military court. I mean, he was taken out of the civilian system and tried in a military court. And the Supreme Court said, well, maybe that could happen, maybe not. But in your case, you win because the civilian courts in Maryland, where you had been arrested, were still open and operating. So they sort of punted on that, if you will. um, I forgot that during Reconstruction, there was another suspension in a number of uh, counties um, in one of the Carolinas, I believe it was. Um, and there was a suspension there because it was found by the Congress that a number of people who had been fighting, on behalf of the South during the Civil War were still, engaged in sufficiently, violent, action against the presence of federal troops in the South that it was, you could consider it an insurrection.
So, yeah, I just want to, I mean, when we're talking about, what Stephen Miller had mentioned, and, I'll let you talk a little bit about the comments that he made and respond to it. But the the mechanism of habeas for people who are being illegally detained currently, we've seen it work for people, non-citizens, students that have been, picked up by this government, placed in detention, and but for like the quick action of some attorneys to be able to file a habeas petition. I think over the past week, we've seen relief, I think, in two instances. I don't know if they were both habeas cases, but I think that both the students were, right? The Tufts University and forget the other one. But so what we're really talking about right now is the mechanism of habeas being used against the Trump administration that's trying to exert power and quickly pick up people, whether it's, non-citizens at this point. But the concern is he'll start going after public officials like what he did in the judge in Wisconsin and arrested her. But that person was able to get released. But in the event that the federal government or Trump says, no, we're just going to detain you, the importance of habeas right now is so important. So it is a long wind up to, can you talk about the present moment and kind of what's going on and why the mechanism of habeas is so important and what's so troubling about what Stephen Miller and the Trump administration have at least openly acknowledged now with considering with this backdrop of understanding that suspensions happen in these very extraordinary times?
Sure. What we've seen this spring is an effort by the Trump administration to do what President Bush did with the Guantanamo prisoners, to do what the Immigration and Natural Service, did with respect to the people who couldn't be, sent back to their, home countries in the late 90s and early 2000s. To do what Lincoln did during the Civil War, ordering that people just be seized, call it an arrest, call it a detention, call it whatever you want, to take people and put them behind bars, deprive them of their liberty, just because the president says, or his minions say, that this person is a danger to the United States. That's what they've been doing with these students who are seized, even though they're legally in the country, because in one instance, a person wrote some things about Hamas, because people said that what Israel was doing in Gaza was wrong, because people protested on college campuses. That is, people exercised their First Amendment rights to express their views about current issues, not inciting to violence, not saying pick up arms, not chaining themselves to fences or gates and blocking public streets, just speaking words or writing words that the administration doesn't like. For every or virtually every action that they've taken that was challenged in court, the federal courts, up to and including the U.S. Supreme Court, have said, no, you can't do that. They have said, you can't just put people on planes and fly them out of the country to El Salvador without giving them any process. You can't hold people in prisons, detention centers, prisons, behind bars, without giving them the right to say, yeah, wait a minute, I didn't say anything. I'm here legally. I haven't ever committed a crime, or whatever other denial of the government's allegation that a person could make. No opportunity to do that. And the federal courts have said repeatedly, both through civil rights actions and habeas corpus writs, these people have to have process. You can't do that, Mr. President. So Miller now says publicly, Stephen Miller, top aide on immigration and whatever other matters, who knows, to President Trump, says we are exploring the idea of declaring an invasion to justify our suspension of the writ. He says, looking at what the federal courts have said, you're wrong, Mr. President, these people are entitled to process. Well, one way we can get around those rulings is to actually suspend the writ, to declare an invasion. The president and his minions have used the phrase or word invasion frequently, both in the campaign and as president, to describe the movement of individuals across the southern U.S. border from Mexico. They say that a gang with roots in Venezuela has invaded the United States because some scores or hundreds of gang members have entered the country illegally. They say that they describe the people who have come into this country and who are in this country as being criminals, rapists, mental defectives, and using all sorts of other unpleasant descriptors. All of the articles that I have read since Miller has thrown out this notion of invasion have said, in polite legalese, you've got to be kidding. If you weren't so close to Trump and speaking for him, this would be a joke. Mm-hmm. The word invasion in the suspension clause of the Constitution from the founding in the late 1780s on, and in England, has meant an incursion by an armed force of a nation state, and only an incursion by an armed force of a nation state. It has never been thought to include a group of people, whether gang members or not, whether carrying a firearm for criminal purposes or not, crossing the border illegally. But he's talking about it. And that's scary. That's an indication of how far they are willing to go. The Trump administration, is willing to go to try to carry out a policy that is based primarily on untruths. The untruths being who and what the overwhelming majority of people who are in this country illegally are. The truth being that the overwhelming majority are hardworking people paying into Social Security, paying their taxes, with no opportunity to ever get any Social Security benefits, contributing to this country's economy, starting businesses, often legalizing their status when they can, not violent criminals. It is so reminiscent of what the Bush administration said about the men in Guantanamo. President Bush, Vice President Cheney, Secretary of Defense Rumsfeld called them all the worst of the worst. Oh my God, they wanted us all to view the people in Guantanamo as animals, as devils. I can't speak to all of them, but I can tell you from my personal experience with the men I represented there and my communications with lawyers who represented other men and people who did studies, the overwhelming majority of the prisoners in Guantanamo were not the worst of the worst. To be sure, there were some people who fought with and for the Taliban. To be sure, there were some people who were hardened criminals in the sense that they engaged in terrorist acts against the United States. But that was not the overwhelming majority. But that's what the Bush administration wanted Americans to believe to justify what they're doing. And that's what the Trump administration wants the American people to believe to justify what they're doing in terms of rounding up immigrants to this country.
I think in one of the recordings, we talked about how the Trump administration is using non-citizens as to help soften the ground, test the limits of the executive power. And when you talk about the suspension of habeas in this context and the rhetoric and that he's using against non-citizens and then using that as a way to invoke the invasion sort of prong of invasion or insurrection. Let's talk a little bit more about the insurrection component of this, because if the Trump administration is using this expansive, pervasive understanding of invasion, one of the concerns that I've had conversations about is then the expansive, sort of perverted interpretation of insurrection. And he's already used language for political opposition and Democrats and people on the left, people protesting as radical leftists, as people causing, insurrection-like type of behaviors or qualities in the United States. This to me is where the expansion goes to citizens and not just non-citizens, which is why it's so important to push back and make sure, that this doesn't happen. But I mean, what are your sort of immediate reactions to sort of those concerns or fears?
I think that the concerns that you just articulated are very real. They are grounded in the reality of what we have heard. The Trump administration just caused the arrest of the mayor of Newark. The mayor of Newark, New Jersey, wanted to go into a federal detention facility built to house illegal immigrants with the code enforcement staff of his government, city government of Newark, to determine whether or not that facility had complied with the Newark, New Jersey building codes. He wasn't permitted to enter and he was arrested. The rhetoric that we've heard about former Congresswoman Liz Cheney is precisely the type of rhetoric that you just went through, Bobbin. They have said that Liz Cheney should be prosecuted. They have said that Liz Cheney, it committed treason, and it starts with words. If we look at the history of despots, dictators, authoritarians, autocrats, call them what you will, one sees you start by calling people out as being bad people, whatever the badness happens to be. Pro-Hamas, anti-Trump. I mean, you take it to the extreme, and what you articulated is, applicable to Liz Cheney. She was very clearly and outspokenly anti-Trump. She warned about the dangers that our democracy faced if he were to be reelected. So did her father, Vice President Cheney under Bush. Hardly a progressive person, a person whose views and actions as a large corporate person before he became vice president were about as pro-military and pro a very strong presidency as one could get. But he said, whoa, this is a danger to the country if Trump is elected because of where his rhetoric can lead. So I think that it is perfectly grounded in reality to express a fear that rounding up illegal aliens at the same time as we're hearing rhetoric about U.S. citizens, former Congress people, current Congress people, as being hostile to the United States interests.
Mm-hmm.
And then if the power to seize and detain on your say-so alone is upheld, there's no line to draw. Because as we talked last time, the 14th Amendment applies to any person in this country. In terms of due process, the Fifth Amendment, any person in this country. The suspension clause doesn't say, well, you can suspend it against people who are here illegally, but you can't suspend it against citizens except in these circumstances. It's just the writ shall not be suspended. There's no line to be drawn there from under the Constitution. So I think that the fear is a legitimate fear, and that heightens the importance of preserving the writ of habeas corpus in as full a form as one can.
So, I mean, we've given a pretty in-depth overview of habeas. We've talked about it as a check on state government and state powers. And then we moved on to it as a check on the federal executive in the context of what we're seeing currently. I look at the Bill of Rights. They talk about the First Amendment being, the democratic amendment, in the sense of without free speech, assembly, religion, the democracy is completely undermined. I mean, I've also heard, and I think I agree with all the Bill of Rights is meant there to protect, democracy at its core, the Fourth, Fifth, Sixth Amendment, the Eighth Amendment, the 14th Amendment. But when we talk about a mechanism like habeas corpus, I look at this as so fundamental to the line between a society that has some scintilla of a democratic institution or practice of democracy to not being there, to being a complete oppressive government at that point. Is this one? I mean, we're sort of confronting all these different inflection points, these threshold sort of institutions, values, principles that once they are broken or crossed or no longer honored, we've sort of meandered into into fascism. But with the writ of habeas corpus, I mean, if we cross that line and it is suspended, where are we at?
If we cross that line and the writ of habeas corpus is suspended by the Trump administration, we're a long way down the road to an autocratic system. If we cross that line and the writ is suspended by the administration and upheld by the Supreme Court, I think that we have lost our democracy in all but name. Yeah, the executive will then have achieved an assertion of power over all of us that is fundamentally at odds with the notion that is in the Constitution, that unless powers are enumerated and given to Congress, they're reserved to the states and they're reserved to the people.
It seems like we're coming to that conflict at some point where the administration will likely try to suspend habeas.
I don't know, Bob. I'm not going to look into that the crystal ball that you're looking into. I'm too far away. We're on the other sides of a computer screen. What I am willing to say is that it is a distinct possibility.
Yeah.
The other thing that I'll say is that in preparing for today and in looking back at what was said, not just by me and in the articles I wrote and speeches I gave during the Bush administration and after the Guantanamo work, but going back to the Reagan administration and going back to the Nixon administration, going back to Joe McCarthy, going back to what people said about Roosevelt in the 1930s. People have expressed concern periodically, repeatedly throughout the history of this country about accretion of executive power, expansion of executive power. And we have had cycles in our country in which executive power has expanded and then it has been stopped and there has been retrenchment. And I do not give up hope that the excesses that we are seeing, and not just with respect to habeas corpus, but across the board in chilling speech and in chilling economic activity, chilling association, that those will be pushed back. We've still got people like Cory Booker willing to stand up for 25 hours on the floor of the United States Senate and say, folks, look at what's happening. We need to stop. We've got a beautiful, image of American diversity. Bernie Sanders, 83-year-old Jewish guy from Brooklyn in Vermont, raising hands with Alexandria Ocasio-Cortez, darker skinned female from the islands, raising hands saying, listen, democracy isn't dead. People didn't buy Elon Musk's money and words in the Wisconsin race. We need to have hope. We need to continue to believe in the power of the people. Lincoln, government of the people, by the people, for the people. We, the people, have a voice. All of us. I've got a voice that was trained in a law school. But everyone has a voice, a skill, and an ability to speak up, whether it's to go to a protest, whether it's to write letters to the congressman, whether it's to give money, whether it's to join associations and groups that are promoting our democratic institutions. I hold out that hope. I'm not ready to give up or give in to the Stephen Millers or Donald Trumps of the world.
And I feel the same way. I think that was the question I wanted to end with was, how do we fight back? What is, what is the steps that we need to take and, and how to have hope. And I do think, like, naturally I'm an optimistic person, and I do feel I see a lot of wonderful things happening at the national level. You see tremendous lawyering happening, pushing back against the Trump administration, federal court judges standing up for the rule of law, protecting people. And, we will come to some inevitable conflict and tensions, but yeah, I think there is a light at the end of the tunnel if we can coalesce around and understand that the things that we're fighting for and what we're trying to protect, which is, our way of being able to treat each other with dignity and, to protect each other's rights and liberties. So, well, I'm glad you finished with that is all I want to say. But thanks for walking us through habeas and where we're at. And, it's just a really fascinating legal history and tool that exists. And I think such a powerful, just a very powerful thing in the U.S. law. And there's a T-shirt that I used to have. I can't remember if the ACLU made it or nothing, or someone made it, but it said "Habeas Corpus is for lovers." And so And I think, I have a full appreciation for that. Lovers of rights, lovers of dignity, lovers of democracy. So thank you, Steve, for being with us this week, and we'll be back with another episode of Waxing Confidential in the upcoming weeks. And thank you for listening, and thank you to our producer, Todd Davila. We'll see you soon.